Welcome to All Things ADR, the podcast. My name is Muleba Joseph Chitupila, and I will be your host. In today's episode, the very first, I'm thrilled, excited to introduce to the audience Honorable Justice Charles Kajimanga, retired Supreme Court Justice and a chartered arbitrator. Welcome, Judge.
Thank you very much, and I'm happy to be here.
Okay, thanks for making time to join us. Today's episode, being the first one, takes us back to the very basics and the building blocks. ADR. What is ADR? That is alternative dispute resolution. Obviously, ADR provides us with the means of resolving disputes outside of the traditional means, such as litigation. So you then talk about arbitration, mediation, construction adjudication, conciliation as well. Those are the basic building blocks. But we'll have the expert dive deeper into them and then give us more into terms of the landscape. So, over to you, Judge. What does the ADR landscape in Zambia look like?
Thank you for that question. I think that the landscape for ADR in Zambia looks quite dynamic. It is dynamic, and it is supported by an appropriate legislation, legal framework. But I think I would also add that it's still maturing.
Okay. And with that in mind, Judge, maybe if we started going into it a little more deeper, what would you say are the I spoke to them in the at the beginning, but give us a little more detail of the various forms of these ADR.
Okay, so we have a number of ADR mechanisms. I'll start with arbitration. This is a mechanism where parties appoint a neutral third party to resolve their dispute. This neutral will hear the evidence from the parties and render an award, which is final and binding. It's not subject to appeal in this country, according to our legislation. We also have mediation. This is where parties get a neutral third party, but this one doesn't make a decision for the parties. It just helps the parties to reach a settlement. And once that settlement is reached, it's registered in court, because in Zambia right now, mediation is court annexed. We also have construction adjudication. This is where if there's a construction project going on, and a dispute arises between, for example, a contractor and a subcontractor, which requires urgent resolution so that the execution of the project is not delayed. So an adjudicator is appointed to resolve that dispute. We also have conciliation. This one is common in the labor realm, where if parties do not reach an agreement, they can get another neutral, is also neutral, who will be able to help them to resolve the dispute so that they can proceed.
Okay, that's a good starting point. Now, obviously, one of the things I would like us to just go back. I think the first one you mentioned was arbitration. Are you able to give our listeners a little more insight into who are the players when we speak of arbitration? Like, who are the actual players who then take us through the whole arbitration cycle?
Okay, so in arbitration, the players are basically, we start with the arbitrator or the arbitral tribunal, who is appointed either by the parties or by an institution, depending on what the arbitration agreement says. Okay, but for arbitration to take place, there must be an arbitration agreement. It's not like court where you can just take someone to court without their consent. But in arbitration, there must be an arbitration agreement in place, agreed to by the parties.
So that is our foundation, the arbitration agreement.
Yes, that's the foundation, because without it, there can be no arbitration.
Okay.
Okay, so the other players are obviously the parties themselves, the disputing parties. And of course, these parties will be represented by either counsel or lawyers or any other person. In arbitration, you can be represented by any person. That person doesn't necessarily have to be a lawyer. It's your choice.
Yeah, and I think just briefly on that, I think it's something we'll see as we do a few more episodes on this podcast, and I think that has to really be made clear that it's not only locked to lawyers, but it's open to representation by even people from other professions. That's something we'll delve into in our coming episodes. But yeah, thanks for also highlighting that.
That's true, yes.
Okay. Anything else you want to add on the players?
Yes. Of course, we also have witnesses. Arbitration is like it's like litigation, which is private anyway. So the processes are more or less the same. So you need witnesses because the parties have to prove whatever claims they're making, and they can only do that through witnesses.
Mm.
And some of the witnesses may be experts. Okay, for example, where a dispute involves a construction project, so you require an expert to help the tribunal to understand exactly what transpired, why a building collapsed. Okay, because the arbitrator may not be an expert in that field, so it will depend on the opinion of that expert, so that he can understand the dispute properly.
And then I know we also mentioned arbitration, and we had moved on to mediation, which takes a slightly different form, in the sense that the decision in mediation comes from the parties having had their discussion and the mediator just guiding them. But just give us a little more detail in terms of the actual players in the mediation cycle as well, and maybe the roles that they do play in detail.
Okay. So, unlike arbitration, the mediator basically, like I said earlier, helps the parties to resolve their dispute, to reach a decision. So it's basically the parties that make their own decision, but with the assistance of this neutral third party who is called a mediator. And in mediation, the players are basically the parties and the mediator. The lawyer plays a very significant role, really, because they are just there to observe what is happening and maybe to give guidance to their clients. But strictly speaking, the main actors in mediation are the the mediator, and the parties themselves.
Yeah. And again, I keep saying this, we'll be having more and more episodes on the podcast, so there'll be one in detail on mediation. But again, you mentioned an important point because from my practice of mediation, and I'm sure yours as well, sometimes I've seen that when a lawyer goes with the parties, the lawyer then gets more and more involved, almost as if they're going back to litigation and maybe arbitration, which is not supposed to be the position. It's basically the actual clients and parties who then speak to the mediator and make the decision. So that's another crucial point to note. Is there anything you'd want to add in terms of the parties for the players in construction and education?
Well, in construction and adjudication, also again, first of all, we have the adjudicator himself or herself, and the disputing parties themselves. Yeah. They are basically, it's not like a hearing as such where you need witnesses and so on, but it's just a dispute is presented to this adjudicator, and you'll be able to assess it and make a determination.
Yeah, and I know the other thing which stands out with construction and education is that it's commonly referred to as rough justice, and that's because largely, like you said, it's done in such a fast mode. Usually, I think you see time frames of 14, maybe 21 days, 60 days at most, because the idea is that you want the educator to make a decision and then get the parties back onto the construction site.
True.
Yeah. So I think we'll use those as our building blocks, education, mediation, arbitration. I think you also spoke about conciliation briefly. But then in today's world, how should we see these ADR forms? Are they rivaling litigation, or should we be seeing them as complementing and working together with litigation?
That's a very important question. ADR is not supposed to rival litigation. ADR is just an alternative to litigation. And in fact, they complement each other. The two systems complement each other. If I start with ADR, ADR is a private arrangement, okay, of the parties, except for mediation in Zambia, which is court annexed, where the court is involved. Okay, because the matter has to go to court before parties are referred to mediation. But arbitration is completely private, and because of that, any decision that they make, an arbitrator makes. If an arbitrator makes a decision, because he's a private judge, he doesn't have the imprimatur of state authority. He's not able to enforce his orders. So that's why parties resort to the court to help them enforce those orders. So in a sense, the court plays a complementary role to make sure that the arbitral process is not rendered effective. So there's no rivalry, and even the Arbitration Act itself in the preamble states as one of the objectives of the Act is to redefine the supervisory role of the court. Now, that supervisory role is redefined in the sense that the courts just help to complement the arbitral process, for example. I say that because an arbitrator cannot enforce his orders, it means that if a party who is successful is not complying with the order voluntarily, the successful party can go to court for enforcement. So again, the court plays that role to complement the arbitral process.
Okay. And I know again from my experience with construction education, it's largely the same. When you have your decision from an adjudicator, you then have it enforced through the mechanisms of arbitration.
Yes.
In a format which takes us back to the complementary role that the court system plays with arbitration as well. Now, I'd like us to move on to maybe the next part, and here, we'd really be looking to tap into your practical experience and what you've seen. What are the practical benefits of using ADR? So, when we talk about arbitration, mediation, construction education, conciliation, what are the practical benefits when I say I'm a user of these methods?
I think the benefits are quite many. And that's why ADR is important. First of all, if you talk about arbitration, it's party driven. Okay, so parties have the freedom to decide how they want their dispute to be resolved. They are free to choose their own rules. They are free to choose the arbitrator that they want to resolve their dispute. So they've got the freedom to do anything. And because of that, and again, there's informality. People are free to do whatever they want to do. But at the end of the day, it's to achieve justice. And if you talk about mediation, it's also one of the advantages is that it helps parties to make their own decision instead of having a decision made by a court which is forced on them. Okay, so that's a good advantage. So parties will be happy that they participated in making their own decision than a decision which is imposed on them. Adjudication, construction adjudication is a sale. I mean, parties will choose someone they think has expertise to help them resolve that dispute. No one will be forced on them. Okay, so that's another benefit. So parties have the control of how they want things to move.
Okay. And then the 2 points you just touched on there was adjudication as well as the parties being able to choose an arbitrator. I think it's a very good benefit because, especially for example, you talk about arbitration, it allows you to pick an arbitrator specialized for a particular dispute. So it could be, say, a dispute which is centered around share purchase agreements, shareholders agreements. And I think you then be able to go into the market as parties and then say, oh, I think I've looked at Honorable Justice Kajimanga. He's specialized in this particular field. He has training for it. And then you go and get him as your arbitrator. I think that helps the decision have a little more speciality around it because the person really knows what the field the dispute is around,
Yeah, that's true. Just to add on what you said, litigation, a judge is given any case.
Mm-hmm.
Okay. They may not have expertise or training in that area, but they're judges. So they are supposed to hear and determine every case.
Yeah.
Yeah, which is to me a disadvantage the parties.
Yeah. Now, and then I'd want us to move on to maybe another benefit. And here, obviously you had served as judge initially at the High Court Commercial Division and then ultimately at the Apex Supreme Court. Give us a feel in terms of the benefit of time. I know most of the time, especially theoretically in the books, we say, oh, the advantage of arbitration, mediation, construction, education, these are faster. Are you able to give us a bit of an example in terms of, okay, when I was on the bench, maybe how you could compare a litigation matter, how long it took compared to, say, an arbitration matter? So, the audience gets an actual feel. How fast is it?
That's another important question. From my experience as a judge in the High Court, serving from the High Court, okay, at the time I was in the High Court Commercial Division, we had special rules which helped us to fast track cases compared to journalists.
Yeah.
And so to that extent, we were able to speed up the disposal of our cases. But when I compare that experience to arbitration, which I'm practicing now, I would say that most of the arbitrations that I've done, in fact, most of them have been disposed of under a year.
Okay.
Yeah. And obviously because of the processes that are involved in arbitration, the procedures used are somewhat different from litigation. Yeah. So I would say from my experience that there's a benefit in proceeding with ADR because it takes a lesser period of time to dispose of a matter than in litigation. But of course, there are certain instances when some arbitrations have taken quite long. Yeah. And if it's mismanaged, it can take as long as a matter in court. Yeah. But overall, I would confidently say that most of the matters I've handled have taken in arbitration have taken a shorter time than in court. Yeah.
And again, this just shows the importance of ADR. You find that sometimes most of the matters that go to arbitration stem from commercial activity. And the overall underlying, is that people want their disputes resolved quickly so that they go back to the business. Because ultimately what you want to do is business and you want to get things across the line. So you don't be tied up in court or the usual litigation, which may take 2.5 years, sometimes 3 years on average, compared to, like you said, maybe a year in arbitration, get it out of the way, get people back to business. I want to move to a slightly more interesting one in terms of the benefits. And I want to hear your view, especially on this, which is the cost. And I'll just take it a bit before you jump in. So I know some people say litigation is cheaper than arbitration, and they usually look at it from the point of view of maybe the fees that are paid to an arbitrator. But I think my experience when you look a little more, in the behind the curtain is that you may pay a little more to the arbitrator, But when you factor in time, and like I keep saying, these things are about commerce and business. You pay someone to get it quicker, you get your decision, you go back to business, which saves you time. And in comparison to litigation, that time is what you don't have. You don't have time to sit down for 3-4 years. Projects start to store, then the expenses in the background. So, with that setting, what's your take? What do you think? Is it cheaper ultimately long term to go for ADR and arbitration perhaps in this particular case? Or, do you say, okay, maybe litigation is cheaper?
Yeah. Well, I would say that generally speaking, arbitration is cheaper in the long run. In the short term, it may look expensive because, like you rightly said, the tribunal has to be paid fees. The party also has to pay the lawyers. They have to pay for maybe the venue where you are conducting the arbitration and all those things. Unlike in litigation where the judge is paid by the state. But in terms of time, because time is money, so time is crucial. Time is of the essence for a businessman.
Yeah.
If he's able to, if he can pay fees to an arbitral tribunal, but if he's able to get his money, his claim, okay, within a short time, I mean that overrides the cost of paying arbitrators, because he will have gotten his money back and plowed it into business and make more money than to wait for 4 years by cutting costs in terms of the judge not being paid by the parties. In the long run, you will have lost that. Okay, in terms of your business. So in a way, I think I can safely say that yes, in the short, it may appear expensive, but I think that when you look at it in the long term, it's better for parties.
Yeah. And I know that argument, to the side of things, stretches to construction and adjudication as well. I know you have your adjudicator who you have to pay, and the lawyers for the parties, but when you look at it long term, it's like arbitration.
Exactly, because you determine that dispute quickly.
Yeah.
And parties continue.
Yeah. So now also, just in terms of the benefits, I just want us to go back to mediation. And obviously, from the time in the High Court, I'm sure you must have referred a number of matters to mediation. I know one of the benefits is at times maybe because of the nature in which it's done, it's a little more friendly. The thought is when it's done, the parties still maintain their relationships. I will just speak to us a little more in terms of what's been your experience in terms of when you refer parties to mediation. How many used to come back and say, "Oh, we failed to resolve the dispute"? How many ended at mediation? And
yeah. From my experience, majority of the cases used to come back.
Okay.
Yeah. And it turned out that counsel was mostly to blame for that.
Yeah.
That's how we analyze it. Those were our findings.
Okay.
Yeah. Parties may be willing, but counsel, for example, may not. They would want to apply for adjournment. They would try all sorts of things to frustrate the mediation process. Yeah, because most of the reports that were coming back were not settled, and the reasons were parties could not agree, something like that. Yeah, but I mean, when you look at the matter, really, you think that this is a simple matter which parties can resolve, which parties can settle and save time and continue with their business relationship. Yeah, but that was my experience.
Okay.
Yeah.
But would be fair to say when it does work, it works very well?
Oh, yes, because when it does work, when mediation works, like you pointed out, you mentioned that parties. You see, mediation, the advantage is that it's a win-win situation. Okay, parties leave mediation feeling happy that they've been involved in the decision making process, and at least they've taken something for themselves. They're happy, and they'll be able to continue with their business relationship. Yeah. That's the beauty with mediation. Yeah. So I would encourage it myself.
Okay.
Yeah.
Okay. So I know we've looked briefly at the benefits. Now, all things on, a coin has two sides, is a downside. I mean, based on your experience, what would you say are the weaknesses of the various ADR systems, and what are our options in terms of strengthening it? So maybe we would take it arbitration, mediation, and bit by bit. So yeah.
Weaknesses, starting with arbitration. I think it's sometimes it's lack of understanding of the processes by parties. Yeah. So you find that you are in an arbitration, and parties, lawyers who want to proceed as if they were in court. Okay. Using the same the same processes as if they were in court, when it's supposed to be an informal and flexible arrangement or mechanism which is really flexible. Now, so one of the weaknesses is that it is what I've just said: the lack of sensitization among the parties. Yeah. And I think the other weakness also is, the parties themselves. They don't want to comply voluntarily. They think that solemn judgment, which gives them justice. Yeah, they think that they may not get justice from media processes, which is unfortunate. Again, mediation also, one of the weaknesses is that, I mean, because it's not mandatory, so parties may not approach the process quite seriously. And that's why I gave that example that most of the cases will come back. Yeah. Yeah. So really, because it's the parties involved, they may choose not to cooperate. Yeah. Yeah. Okay. That's sure. Those are weaknesses. I mean, But in terms of, you asked the other part was, is it the benefit?
How we can maybe strengthen
work
on these weaknesses.
Yeah, I think for me is to sensitize the public about the advantages of ADR, because if they understood the benefits, they would embrace it. They would embrace it. I mean, like in other countries, it's so embedded in society that going to court should be the very, very last resort. Yeah. Yeah.
And I know there are certain periods across the year where the judiciary encourages mediation hearings. That's one of the places we have our the sensitization, and of course we have the Chartered Institute of Traders Zambia branch, who I think they do quite a bit of sensitization as well, and I mean they are ready to provide any information around it.
Yes.
Yeah. So okay, with that in mind and our landscape slightly, in mind now. Again, I know this is somewhere you've had a bit of experience with. I think the Kenya, maybe South Africa, England. How would you say our ADR space compares internationally? Are we far behind? Do we need a lot of work?
No, actually, we compare very well.
Okay.
Because we have an appropriate legal framework. Our Arbitration Act, for example, is based on the constitutional model law. That's the internationally accepted law that governs arbitration everywhere.
Yeah.
Okay. Zambia is also a member of the New York Convention. And so, in terms of the legal framework, we compare very well internationally. What we are lacking is that we don't have a sufficient pool of qualified practitioners in India compared to most other countries. So we are still maturing. Yeah, we are still evolving. And also, what we lack is that very few people would want Zambia to be a seat of arbitration, for example, in these international disputes. Because we haven't yet marketed ourselves as an appropriate seat for arbitration, for example. But the advantage we have also, or the plus, is that our courts are arbitration friendly. Okay, so that's one of the things that discourages parties from choosing a particular seat. If the courts are not arbitration friendly, parties will be reluctant to choose those seats. But for us here, if you've read most of the decisions of the court. They are pro arbitration. They are there really to complement the arbitral process. Yeah.
And I would just add that from the conferences I've attended internationally, I think Zambia is given quite a bit of credit in terms of where we sit in terms of the ADR system. So it's quite a bit of recognition around that. And recently we've had the Lusaka International Arbitration Center launched. So that may also help pushing us towards recognizing Zambia as a good seat. Yeah. So I think we've sort of had our landscape set out, the benefits, the weaknesses. Of course, this is just always a teaser. We're just putting things out there for our audience in Zambia. So maybe, Judge Kajimanga, do you have any last parting words for our audience? I have something at the end. It's around the judge's book, but we'll get to it at the very end. But do you have any last parting words for our audience?
Yes. I want to encourage parties to think serious about ADR. It's a very useful mechanism for resolving disputes. I think that courts are inundated with a lot of backlog, and parties or the people should understand that even a decision from ADR is as good as a decision from the court, because it can be enforced like a court. For example, an award can be enforced like a judgment of the court. So, but they should look at these advantages that come with the ADR processes. So I would encourage people to think seriously about resorting to ADR before they think about going to court, because there are all these benefits I alluded to briefly. So that, I think, is what I would want to lead with the out there.
Okay. Yeah. So lastly, as I said, the one thing I may have just mentioned at the top of our episode is that not only is our judge a chartered arbitrator, he is also an author of the handbook on arbitration in Zambia. He co-authored it with Honorable Justice Nigel Kalunda Mutuna. I'm not sure it's clear for us to see. But as one of our giveaways, we'll be giving away a signed copy by the judge. Obviously, our pages will indicate how we'll select the winner on the page, but yeah, we will be giving out a signed copy by the judge. Otherwise, thank you so much for making time to meet us, Judge, and we look forward to having you maybe again on another episode.
Oh, it's been my pleasure participating in this first episode, and I look forward to being involved again in the future. Thank you very much.